My name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case State v. Linscott. This case was heard in the Supreme Court of Maine in the year 1987. Let's go ahead and jump into the facts of the case. So Linscott had a friend, Fuller. Linscott and Fuller devised this plan that they were going to rob a drug dealer. This drug dealer's name was Grenier. Fuller had bought some cocaine off this drug dealer recently, and Fuller said, "Hey man, the drug dealer's got $50,000 in cash. If you help me do this robbery, I'll give you 10 grand. So they hatched this plan. Now they set this plan in action, and that night they drove to the house of the drug dealer, and Fuller had a shotgun with him. So they were planning on how they were going to get in to the house. Now, the defendant in this case, Linscott, broke the window with his body. He broke the window. And as soon as he broke the window, the drug dealer came there, and he was standing there in view of Fuller. Fuller pulled out his shotgun and shot the drug dealer. So the drug dealer hits the ground, and sadly he dies as a result of this. Linscott, the defendant, took some cash off his injured body, and they both fled the scene, but they were eventually caught. Now Fuller was charged with murder and robbery, but that's not the case here. The case that we are looking at is Linscott. Linscott was charged with robbery because he took the $1,300 off of Grenier and he broke into the house. And then he was also charged with murder on an accomplice theory of liability. Now, he was convicted of this in the trial court. He waived his right to a jury trial, but he appeals this. And what he says is that I didn't have the intent that this guy Fuller that I went with to go rob this guy, that he was going to kill him with a shotgun. Like, yeah, I knew he had a shotgun. He's a hunter. But I had no intent that he was going to murder Grenier, the drug dealer, when we were breaking in. So I shouldn't be on the hook for the murder. Now, the court on appeal rejects that argument. And the reason they reject that argument is because of the natural and probable consequences doctrine. And that's the key of this case, the natural and probable consequences doctrine. It's a common law formulation. And this rule allows an individual to be guilty of a higher offense than what they intended to if they were accomplice with another. So in this instance, it doesn't matter that Linscott didn't intend that Fuller was going to kill Grenier when they were robbing him, when they were commissioning the burglary. It doesn't matter. All that needs to occur is that it needs to be the natural and probable consequences of the crime that the further act would occur. It's kind of like proximate causation in torts. It needs to be reasonably foreseeable that if you begin an armed burglary, that your accomplice will shoot someone and kill someone. And the court says it's totally foreseeable that if you go to rob someone with a shotgun, that your accomplice, the person who you're robbing this person with, is going to use that shotgun and shoot that person. And if someone shoots someone, then it's also reasonably foreseeable that that person who gets shot is going to die. So sorry, Linscott, but you are on the hook for the murder, whether you intended that your accomplice would do that or not, because it was reasonably foreseeable that if you were an accomplice in an armed robbery, that someone would get shot. So the conviction is affirmed. It's worth noting that the natural and probable consequences doctrine does not apply in the MPC. The Model Penal Code has rejected this doctrine. And to show why you might want to reject this doctrine, just illustrate a case. So let's say that you and your friend decide to rob a convenience store. You're going to go rob a convenience store. You want to get a bunch of gum. And you have an airsoft gun. It doesn't have real bullets in it. It's an airsoft gun. And it looks like a real gun, right? And so you drive your friend to the convenience store. He goes in with his airsoft gun, and he points it at the attendant at the gas station and points it to him. It says, "Hey, give me your money. I want to steal everything here. I want to steal all the gum. I want to steal the money out of the till." Well, the attendant is so frightened that they have a heart attack and die. Now, on the natural and probable consequences doctrine, you would probably be guilty for the murder of that person, even though you were just driving the car. And the reason that is that if you're an accomplice in an armed robbery where you have a gun that looks like a real gun, it's reasonably foreseeable that someone will be frightened by that real gun and would be frightened to the point that they would have a heart attack and die. I think that's the boundary of the natural and probable consequences doctrine. But it shows that this doctrine could lead to some unintuitive results where it seems like we're going to charge someone with murder or a very high crime when their intention was much lower. So that probably is why the model penal code rejected it. But it also, you can see in a case like this, State v. Linscott, where it would be helpful to a prosecutor and to justice, perhaps, that these people get charged with murder. If you know that the natural and probable consequences doctrine is a thing, which Linscott obviously didn't, but if he would have known that this was a thing, probably wouldn't have gone to the robbery at all with a person who had a gun, because he would know that something terrible could happen there and he'd be on the hook for it. Now, Linscott was probably just ignorant of that. He probably thought, well, if he shoots him, I'm not going to be on the hook for it. I had nothing to do with that. And so that's where you can see the ex post versus the ex ante argument going on there. Thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day.